I begin going count by count. Allow me also to state on two important questions, and I want honorable members to listen. Two things are important. That this is an historical moment and it is also a constitutional moment because Kenya, under the 2010 Constitution, has never dealt with the impeachment of a deputy president. However, we have dealt in numerous times with the impeachment of governors. And our courts of law have set the threshold on which impeachments should be considered. And I thought from the onset, it is important for me to set out the threshold on which impeachment should be considered, so that as I take you through the evidence that we have, you can gauge the evidence against what the courts of law have decided. Mr. Speaker, allow me to read paragraph 31 of Civil Appeal number 21 of 2014, famously called the Wambora decision. The Wambora decision is now the locus for most of the impeachment cases and has been cited with approval by our Supreme Court. In paragraph 31, the court stated as follows: our reading and interpretation of Article 181 of the Constitution, as read with Section 33 of the County Government Acts, shows that the removal of a governor is the constitutional and political process, underlying constitutional and political process. It is a sui generis process that is quasi-judicial in nature, and rules of natural justice and fair administrative action must be observed. What I'm going to read is the most important part. The impeachment architecture in Article 181 of the Constitution reveals that the removal of a governor is not about criminality or culpability, but is about accountability, is about political governance, as well as policy and political responsibility. Mr. Speaker, the coaching of Article 181 in the Constitution, which relates to removal of a governor, is similar to the coaching of Article 150, which relates to the removal of a deputy governor. And therefore, mutatis mutandis, what the Court of Appeal did state, that the removal of a governor is not about criminal or culpability. It is about accountability, political governance, as well as policy and political responsibility applies to the removal of a deputy president. Mr. Speaker, the standard, I am prepared this morning to discharge my burden of proof, because he who alleges must also prove. And I am ready to discharge it to the required threshold. Therefore, Mr. Speaker, in consideration of the time that I have been given, allow me now to go to the specific grounds. Ground number one, Mr. Speaker, ground number one, briefly. On ground number one, Mr. Speaker, we have alleged that the Deputy President has grossly violated the Constitution, and particularly Article 10(2)(a), Article 10(2)(b) and C, Article 27, Article 73, Article 75, Article 129, Article 147, and Article 131. Mr. Speaker, for clarity, allow me to read out the specific provisions so that members may relate with what we are saying. Article 10 is about national values and principles of governance. Article 10(2)(b) states as follows: the national values and principles of governance include patriotism, national unity, important national unity, sharing and devolution of power, the rule of law, democracy, and participation of the people. B, human dignity, equality, social justice, inclusiveness. Underline the words national unity and inclusiveness. C, good governance, integrity, transparency, and accountability. Mr. Speaker, we have also alleged that the Deputy President has breached Article 27 of the Constitution. Article 27 of the Constitution is about equality and freedom from discrimination. In particular, the Article 27(4) states as follows: the state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, and so forth and so forth. Important, the state shall not discriminate. Mr. Speaker, we have also alleged that the Deputy President has breached Article 73(1) of the Constitution. In particular, Article 73(1) is on leadership and integrity, and it speaks to the authority that is assigned to a state officer. And it states as follows: Article 73(1)(a), that the authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and objects of this Constitution. Article 73(2)(b) states that the guiding principles of leadership and integrity include objectivity and impartiality in decision making, and in ensuring that decisions are not influenced by nepotism, favorism, underline favorism, other improper motives or corrupt practices. Mr. Speaker, we can go on and on to demonstrate in Article 75, under Article 75(1)(c), that the conduct of a state officer shall behave, whether in public and official life, in private life, or in association with other persons, in a manner that avoids C, demeaning the office that the officer holds. Mr. Speaker, I am taking time on this one because it is important to demonstrate that the Deputy President has not lived up to the high calling of the office that he holds, and thus has violated the Constitution. Article 129 is about the principles of executive authority. And particularly, we have said that the Deputy President has breached Article 129(2). Article 129(2) states that the executive authority shall be exercised in a manner that is compatible with the principles of service to the people of Kenya and for their well-being and benefit. We have also alleged that the Deputy President has breached Article 147 in conclusion on this particular ground. And Article 147 is about the functions of the Deputy President. And it provides that the Deputy President shall be the principal assistant to the President and shall deputize for the President in the executions of the President's functions. Article 131 is the one that provides for the authority of the President. And under 131(2), it provides as follows: that the President shall A, respect, uphold, and safeguard the Constitution, and C, promote and enhance the unity of the nation. Promote and enhance the unity of the nation. Mr. Speaker, it is our allegation that on numerous occasions in the last 2 years, the Deputy President has used divisive language He has described the Kenya government as a company. He has described the Kenya government as a shareholding company, where it is only the shareholders of the company who should benefit. And it is our contestation that that particular shareholding language contradicts and contravenes and violates all the provisions of the Constitution that I have highlighted above. Mr. Speaker, the Constitution does require, even at the preamble, recognizes that Kenya is a multi-ethnic society. We have about 45 ethnic groups in this country, big and small. And all of them are recognized by our Constitution, and all of them need to enjoy their equal rights. And the Deputy President has consistently told Kenyans in several places of this country that some will benefit from government and others will not benefit from government. Mr. Speaker, I need not waste a lot of time prosecuting this point, because those of you who listened to the Deputy President yesterday, he did admit that he has been using the shareholder and company language against Kenyans. The only thing that he did, and when there is an admission by the accused person, the prosecution does not need to prove a point. And therefore, I will be urging members of this House to find that this allegation is proved, and to find that the Deputy President indeed did admit that he has been using the shareholder language, only that for the first time, and this is important, Mr. Speaker, for the first time, the Deputy President did, while admitting, he said that he has been referring to the shareholder company language in reference to coalition agreements. The evidence that I'm going to present shortly will demonstrate that he has never, in his utterances in the last 2 years, talked about coalition agreements or power sharing deals that were signed before the election among the Kenya Kwanza political formation.